Hello everyone, welcome back to my channel, Legal Mindset at the Bar. In today's video, we are going in for land law 1, and our topic of emphasis today is going to be the topic of fixtures and chattels. So, this is a very crucial topic which everybody of you needs to understand so as to be well to go with land law 1. And we are going to discuss this topic in parts. We are first going to see fixtures, we shall see the chattels, we shall see the determination of whether an object is a fixture or a chattel, and we shall see the classes of fixtures. So let us dive into it. And to begin with are the fixtures. The fixtures in a layman's language are those property permanently affixed to the land when they get their roots from the land. A clear example is a house. If you build a house, it is part of the land, because if you remove the house, you are destroying the land. So the fixture must become part of real property. It should become part of the land. Anything you attach to the land and becomes part of the land is a fixture. And at the end of your tenancy, it is passed over to the landlord, the owner of the land. Now, we are going to see some authorities which discuss and define a fixture. We shall start with Section 18, subsection 4 of the Landlord and Tenant Act 9 of 2022. So, that act defines a fixture as personal property of the tenant that is affixed to the premises or part of the premises, so as to be regarded as immovable property of the premises. You see, this is trying to show you that a fixture, when you put it on the land, it is movable. When you remove it, you're destroying the land. We shall go on to an interesting case of Billing versus Peel. And in Billing versus Peel, Lord Goddard stated that a fixture is something so attached to the land, forming an integral part of it, such that the thing and the land are one thing. You get, colleagues? This defines it very well. I will now take you to the Black's Law Dictionary, 9th edition, at page 713. For it, it defines a fixture as something like as a personal property of the tenant, permanently attached to the land, becoming part of the land and real property. So now we have seen the definition of a fixture according to different authorities. Now we shall go on and look at the Latin maxim of quick quid, planted tu solo solo sedit. This maxim shows you the rights of a landowner over the things attached to the land, and it means that whatever is attached to the land becomes part of the land. Quick quid, planted tu solo solo sedit. The Megary's manual on the law of real property defines it very well, because the Megary's manual on the law of real property says that even if one building is constructed using stolen materials, they all in law become a gift of the ultimate and absolute owner of the land. Look at that extent. Even if the materials are just stolen and you use them to build a house, any property on anyone's land, they become part of the land, a property of the land owner. You get, colleagues? If you affix something to the land, it is given to the owner of the land, because it becomes part of the land. Now, I shall take you through some cases which elaborate and explain more about what a fixture is. Now we shall go at the case of Holland versus Hodgson. This is a locus classicus when it comes to fixtures. And this case, there was an agreement for a mortgage. Holland mortgaged the land. He started affixing looms, machines onto the land, but he later failed to pay the mortgage. Then, when he failed, he had to vacate the land. When he was leaving, he wanted to remove the machines he affixed to the land. However, the landlord found out the owner and he stopped him. The issue now went to court. Now, court stated that the looms, the machines had become fixtures and a property of the landowner since they were permanently, since they got their roots from the land itself. They had become fixtures and are property of the landlord. The similar principle was applied in the case of Francis versus Ibitoye. And in Francis versus Ibitoye, there was an agreement for sale of land. Before the agreement was completed, Francis now started building on the land. As he was building on the land, in the middle way, the agreement failed. The agreement collapsed. When the agreement collapsed, Francis then went to court urging that Ibitoye should pay him for the money used to erect the buildings on the land. Court held that the buildings erected on the land had become part of the land and that Ibitoye was under no obligation to compensate Francis since the buildings had become part of Ibitoye's land and they were now Ibitoye's property. Hope you are now understanding what fixtures are. Now, I shall take you through an interesting case of Jordan versus May. In Jordan versus May, court held that the generating plant, which was set in concrete, was a fixture, but the battery running it was a chattel. Colleagues, you're getting it now. Fixtures are permanently attached to the land. Now, allow me to take you through chattels. And the chattels, these ones are, let me define them according to the Black's Law Dictionary, 9th edition, which defines chattels as personal property of the tenant temporarily attached to the land and they are not part of real property. For chattels, they are temporarily attached to the land. Chattels rest on land on their own weight. We shall see examples of chattels. We shall see the tables, the pictures on the walls, your chairs in the house. All those are chattels and you are entitled to remove them at the end of your tenancy. So now we shall go to the determination of whether an object is a fixture or a chattel. And here, since we are law students, we are going to look at the authority, the book of John T. Mugambwa, Principles of Land Law in Uganda, at page 52. And this book gives us two broad principles which differentiate that this is a fixture or a chattel. These principles include, number one, the degree of annexation, number two, the object of annexation. You can also call it the purpose of annexation. Now, to begin with, the degree of annexation. The degree of annexation refers to the extent to which the object is attached to the land. The general rule here is objects that are permanently attached to the land are considered to be fixtures, whereas objects that are temporarily affixed to the land and they are affixed to the land with their own weight are considered to be chattels. Colleagues, I urge you to understand this very clear. Objects permanently affixed to the land are considered to be chattels. And now, let us now go to the object or the purpose of annexation. This one is the reason for the annexation of the thing on the land. The general rule here is that objects which are put on the land for the utility and enjoyment of the land itself are considered to be fixtures, whereas objects that are put on the land for the utility and enjoyment of those objects themselves, they are considered to be chattels. Hope we are clear on that. And for the purpose of annexation, we shall look at the case of ATC, Uganda versus Kampala Capital City Authority. And in this case, the argument was whether the masts were fixtures or chattels so as to be levied tax over them. If they were immovable, they could be levied tax over them. Now, court applied the purpose of annexation and held that though the masts were affixed to the land, their purpose of annexation was not for the enjoyment of the land, but it was for the enjoyment of the masts themselves. Hence, they were chattels and could be flexibly movable to any other area. We have seen it. We have seen the determination of whether an object is a fixture or a chattel. Now, let us go to the categories of fixtures. Here we have the landlord fixtures or non-removable fixtures. Those ones are properties which a tenant attaches to the land and they become part of the land permanently and they are not entitled to their removal. We also have what we call the removable fixtures. And under those removable fixtures, we call them at times tenant fixtures. These ones can be removed from the land. At the end of the tenance, you can take your fixtures. And these ones are like the exceptions to the removability of fixtures. Let's go now into details of the tenant stock removable fixtures. Now, if you go on and look at section 38, clause 1, section 38, subsection 1b of the Land Act, you will find out that it says the occupant may remove any structure from the land except at the end of their tenance, except dams and trees. I urge you colleagues to look for that authority. Now, let us go into details and see the examples of the tenant fixtures. We shall look at the trade fixtures, we shall look at the ornamental stock domestic fixtures, we shall also look at the agricultural fixtures. To begin with, the trade fixtures. These ones are like items you place on the land for purposes of trade. You go in a new place, say an example town, you put your mobile money shop anywhere. At the end of your tenance, you can remove it. I urge you to go and look at the case of Bain versus Brandt, and in that case, court held that fixtures that entitled to be removed by a tenant after the end of their tenance include those put for purposes of trade and those put for purposes of agriculture. Now, let us now move to ornamental stock domestic fixtures. These ones, the tenant is also entitled to their removal after the end of their tenance. These ones include these tables, those curtains, the pictures, things like that. You are entitled to their removal after the end of your tenance. We shall go on and look at the agricultural fixtures. The agricultural fixtures, like you can look at the greenhouses, the irrigation systems. You can also look at very many things under that category. After the end of your tenance, you can remove your greenhouses and go with them since they are agricultural fixtures. Colleagues, we should call it a day. And that was our discussion on fixtures and chattels. I urge you colleagues, for purposes of more understanding, we have another channel. It's called Regis Agora, Agora Regis. You can go there. We urge you to subscribe, share, and like our videos so that we move together. Thank you very much.